All right, everybody, welcome back to the channel. With the Supreme Court case dropping, we've just had a lot of commentary, a lot of videos being posted by governors. You know, we saw the governor of New York the other day, and we also had a statement put out by Gavin Newsom. So wanted to take a look at that one today. Let's go ahead and roll it.
Today, as you no doubt have heard, the Supreme Court erased a common sense gun safety law in New York State that has existed for decades. Not only in New York State, a law that is similar to those in 7 states, including California. This is exactly the kind of dangerous decision we've come to expect from this Supreme Court. But I want you to know we have been anticipating this moment. We have not been sitting by passively. We've been working closely with our Attorney General, with legal staff, as well as legislative leadership to ready and craft legislation that will be heard next week to protect our public carry law and defend the rights of Californians. But make no mistake, this is a radical decision, one that adopts, in the court's own words, a rigid history approach. A rigid history-only approach that would require gun regulations to be frozen in time from the founding era. As if we should go back and stack our courts not with lawyers to understand the world and the way it was, but with historians. But even historians that do know a thing or two about our past know that the notion of bearing arms in the first place was an idiom. Republican-appointed Justice Stevens said himself, he pointed it out, it was a term used to protect the rights of those to use a gun in conjunction with a well-regulated militia.
So first of all, I can't, once you see something, you can't unsee it. If you have not looked at a picture of Gavin Newsom next to the cartoon version of the Joker, go ahead and give it a look. I just can't unsee it. This guy is one of the biggest villains that we have ever seen in this state. I just absolutely can't stand him. And you got to love, again, this is just all going back to the talking points. First of all, this legislation has been going through our state for the entire year. It's not something that was crafted. Have you ever noticed also the only way that these people know how to legislate anymore is through a crisis? And that's really what he's doing here. He's trying to recreate a crisis so that he can push forward legislation. Not on the merits of the legislation itself. He can't do that because we have so much evidence that shows that the gun laws on the books don't work, which is to say, I mean, if the gun laws in New York worked, why did Buffalo happen? I mean, plain and simple. But these people legislate guns out of existence as much as they can, then they wait for the next tragedy, which, by the way, nobody likes to see this tragedy. And that's another thing he's doing here. He's trying to demonize conservatives by calling them radicals to create the picture that people actually want this. Nobody wants to see people harmed, period. The question, though, is do these laws infringe on people's rights? And do these laws actually work? And I think the overwhelming evidence is that they don't work. What do we got next?
It was a term that was overwhelmingly used for war, a term that applied to a group, like an army, not an individual. Of course, the Heller decision overturned that thinking. And of course, here we are again with another bad decision, recrafting our laws.
I don't really understand this argument either. I mean, this interpretation of the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What does it say about the right of a militia in that statement? The right of the people make up the militia, but ultimately the right of the people to keep and bear arms. What do you not get about that?
With the premise that we exist in the 1700s, a time, as Justice Breyer pointed out, when most Americans lived on farms or small towns. I think it was 1790 alone. New York City was the largest city in America, the size of about 30,000 people, a time when being armed meant muskets.
So I did an interview with one of the attorneys from Michelle & Associates who said that a lot of people were going to be bringing up Justice Breyer's dissenting opinion, and he does it right here. So I guess we can go tit for tat. If you are going to bring up Justice Breyer's dissenting opinion with the false claims that were made there, you should also bring up Justice Alito's concurring opinion, which basically disproved every single thing that Justice Breyer said, literally like line by line, bringing up the question, how do these gun laws actually save lives? At the end of the day, I think what this was pointing to was, if you want to call it a history lesson, when the amendments to the Constitution were written, again, I will reiterate this is a right that is recognized. This is not a right that is given to us by anybody. But there were no restrictions back then on firearms. So if we're going to translate that to today, like we do every other amendment, First Amendment, 14th Amendment, if we're going to translate that to today, there should not be regulations when it comes to charging people with creating a situation that deems it necessary for them to carry a firearm outside the home. The answer always has been and always should be America, because America.